Hello and welcome to Planning Options that work for you and your family. Essentially what we're looking at is planning for blended families. My name is Andrew Gilliland. I do have a Juris Doctorate degree as well as a Master's in Taxation from the University of Florida. Our goal today is to walk you through several options and issues that are unique to blended families. I do love what I do. I have the opportunity to work with you to make sure that everything you have worked for or will work for during your life does not end up in the hands of others or does not destroy your family. To better advise you, I obtained the prestigious degree of Master's in Taxation for one of the top programs in the world at the University of Florida. My goal is to understand you and make sure that your estate plan satisfies your goals. I take the role of legal advisor and counselor seriously and apply my real-world experience to create a solution. I do look forward to meeting and working with you. All right, so what does a blended family mean? So in the estate planning context, a traditional family is one in which any child is a child of both spouses. A blended family includes at least one child for whom only one of the spouses is the parent. So, there's various types of blended families that are out there. If you can remember the show The Brady Bunch, right? In that show, you ended up with Mr. Brady had his 3 boys and Mrs. Brady had her 3 girls. They married, and so they had step siblings. That's your typical blended family case where both spouses have children from prior relationships. There are variations of that where maybe only one spouse has a child from a previous relationship, or where either spouse or both spouses has children or a child from a previous relationship, and then they have a joint child together. That's a blended family. Why is this distinction important? Well, in the first place, as most know, money-related discussions for any family can be challenging, but the dynamics of a blended family can make these discussions more difficult and more critical. Moreover, most default rules, such as intestate inheritance or decision-making authority, etc., were written by the legislature for traditional family values. These rules can sometimes produce unexpected and unwanted results for blended families. Where you'll see this comes up a lot is in intestate, where you have a spouse, second marriage, maybe they're an older couple, the children are grown up, they're adult, mom or dad, they're happy they found somebody else. But what happens when mom or dad passes and it's intestate is now, instead of mom or dad, whom they know and trust, is making the decisions, now it's stepmom making decisions or stepfather making the decisions as to how things go. And not only that, they have certain rights under California law that allow them to take what maybe a bigger or a larger portion of the inheritance than maybe the deceased father or mother would like for them to have taken. So therefore you get sort of unwanted results. Or you could end up in this scenario where we've seen these in movies, and we've seen these, there's plays about them where the stepmom or stepdad basically cheats the children from the first relationship out of their inheritance. Many ways to accomplish that. We're not going to get into them now, but that's what we're talking about here. And that's why a blended family creates a unique set of circumstances, because in a traditional family, the law operates under the concept that both spouses would want the child or children to be treated fairly. Okay, in a blended family, you may not necessarily have that same dynamic, or you may, but the key is that it does create a unique sense of legal issues that need to be addressed and thought through as we go through an estate plan. So there are a spectrum of estate planning options. Okay, we start with do nothing. It literally means you do nothing. The state plans your estate plan through the laws of intestacy. Okay, and as I just previously finished discussing, intestacy favors the current spouse, whether that spouse is a marriage of 1 year, 10 years, or 1 day. Doesn't matter. The law favors the current spouse. So when you do nothing, you're really just accepting the estate plan that the California legislature has put in place for you. We also, the second option there is joint tenancy. What we see in joint tenancy is this is typically where you have, real estate, and you put on it, spouse A and spouse B as joint tenants with rights of survivorship. Another type of planning is what we call TOD or POD, which is payable on death or transfer on death, and other beneficiary forms. Your IRAs, your bank accounts, your retirement accounts, anything that would pass outside because it's a contract between you and the entity who's going to pay it out, and you designate who the beneficiary would be. You've heard of a will. Will is a legal document when properly executed. The will is then taken to a probate court, and the probate court then will appoint somebody, a personal representative, to follow the terms of the will. A trust is also another legal document. We'll talk a little bit about that in a minute. So let's look at do nothing. Okay, so most default rules, we talked about this, intestate inheritance, decision-making authority, etc., are written for traditional families. These rules can sometimes produce unexpected and unwanted results for blended families. You could end up with no say on or control on how your affairs are managed when you're incapacitated. Your default is going to be to your spouse. Again, whether or not that spouse is 1 day or 10 years or 20 years or 30 years, it doesn't matter. Your verbal instructions to your family are not legally enforceable, and it can lead to an expensive conflict when you get into intestate proceedings. The bottom line is this is not a great option. This is the default option. This provides you with absolutely no ability to plan, no ability to be unique to your family needs, none of that. What you end up with is a default rule that says current spouse gets X, children get Y and Z. That's what it happens. And you often end up in litigation over these types of do-nothing plans, because often there is not a lot of agreement between current spouse when the decedent passes and the children. All right, let's talk about joint tenancy. It's very common. It's a basic estate planning tool. The pros are it's easy to set up, it's easy to understand, and it usually avoids probate. Okay, the cons are for blended families, you might unintentionally disinherit family members. And let's stop and talk about that for a second. Years ago, I was on a planning commission in my town. I was the chair, and under the planning commission rules, you couldn't vote. Okay, so basically, I ran the meetings and directed, the votes, and took the votes and directed, the proceedings of the meeting. One evening, there was an old Victorian home that everyone knew quite well. It was really gorgeous, and it had come a couple times before us with an application to kind of get it rezoned, so it wasn't residential, so they could set up like a chiropractor's office or an attorney's office or a therapist office, something like that, into this residence. Well, on this particular night, the owner of it comes before us, and he was an elderly gentleman, and he gave us a whole bunch of background story about the residence. And it turned out that his previous spouse had passed 3-4 years before. He had remarried, and they were thinking of moving to Florida to retire and get a place, he said, on the beach. And so that's what they were thinking. In my mind, I'm sitting there thinking like, oh wow, what just happened here is new spouse is probably going to be on that title as a joint tenant, so any equity in this home then would automatically go to her, because new home would go to her. So the children of this individual would really end up with nothing. And you say, is that really what first spouse would have wanted, the deceased, his wife who had already passed? And is that really what he intended, or was he just seeing it through the eyes of, I love this person, let's go get a new house and I'll put you on the title? Other thing about a joint tenancy, if you say had a child onto your property and there's equity in it, that can cause unintended gift taxes. Okay, if its property is joint owned with a non-spouse. It also can cause increased unnecessary capital gains tax for a surviving joint tenant. Results in an outright inheritance if the joint owner survives. So there's no asset or tax protection. So essentially, when you pass, the other joint tenant on it gets the property outright. Again, not a particularly great tool, doesn't really work well to protect your family in a blended situation. In a typical traditional family, it's very common that individuals do this, and it's very common that it kind of works. At the end of the day, in your typical joint tenancy, when one past spouses, you file an affidavit of joint tenancy, provide a certified copy of the death certificate. You go down to the recorder's office and you put those two together. The recorder will record it, and then that removes the deceased joint tenant off the title and invests title in the joint tenant who's left remaining. Very simple in a traditional family. In a blended family, you have to step back and say, what's the intent with this property? Is it that the new spouse gets it all? Is the intent that this child gets it all? How can we arrange that so we avoid gift tax consequences, provide some asset protection, and generally just provide protection for the family? All right, transfer on death, payable on death, and other beneficiary forms. Again, very common basic estate planning tool. The pros are it's easy to set up, at least when it's available. It's easy to understand, and it avoids probate, usually. The cons are, for blended families, you might unintentionally disinherit family members. So let's walk through that. Often, it happens where you have parents who are aging. Maybe one of them's already passed, so we'll just say you have a deceased mom. Deceased mom is getting up there in years, and her ability to pay bills and to function is, getting a little difficult. Not to the point of incapacity, where someone can take over as a guardian for them. Not to that point, but to the point where they need help. So often what mom would do is put a child on the account, a bank account, for example, with the mother. So now the child's name is on that account, and then the child can write checks, have access to it, and basically run the show. The difficulty with that is a couple things. One is when mom passes, guess who gets all of that money that's left in the account? It would go to the child who is on the account name. The other children may not even know about it. So it would go to the child who gets that. Also, the other problem you have there is any monies in that account, because the child is on it, they're deemed an owner of it, so therefore any creditor issues they have could now access the funds in that account. That's the difficulty with transfer on death or payable on death. There's also no incapacity protection. What happens when mom is incapacitated or dad is incapacitated? What do you do there? And not all accounts or assets can be set up this way. And like joint tenancy, it results in outright inheritance, so you really have no asset or tax protection. All right, so now we'll go through some slides and kind of elaborate a little bit on what I was just talking about. We'll talk about joint tenancy, transfer on death, and payable on death, and how they fell. So in this case, you have three assets: 100,000 bank account, 100,000 real estate, 100,000 IRA or an investment account. You have three heirs. You have a new spouse and two children from a prior marriage. Okay, it seems pretty simple, right? Hey, just give them each one asset: 100,000 for the bank account, 100,000 real estate, 100,000 of IRA, and they kind of move on from there. So we'll say the bank account is a transfer on death to your son from a prior marriage. The real estate is joint with your daughter from a prior marriage, and the IRA or an investment account is payable on death to your new spouse. Okay, we seemingly have equalization here. All right, so let's walk through this. There we go. The bank account goes to the son, okay? Home and real estate go to the daughter. So daughter's put on as a joint tenant with rights of survivorship. And the investment account goes to the spouse. Again, perfectly set up. You feel like you've done it fair. 1, 2, 3, each has a $100,000 asset at the time that the estate plan is made. Now here's the interesting thing. When you do estate planning, you really kind of plan for various cases, right? You plan as if you could die tomorrow. You plan as if you can die in the short term, 5 to 10 years. And then you plan if you can die 30 years down the road, depending on your age and your situation. That's what you look at in an estate plan. So you have to take all those into consideration. Now, in this case, if it all remained the same and you died tomorrow after you did it, right? Perfect. Your estate plan worked. 100,000, 100,000, 100,000. That was the intent. But let's look at this now and assume you die sometime down the road. So what's the value at the time of estate planning? As I just said, 100,000, 100,000, 100,000. Everybody's treated equally. Son, daughter, and new spouse. But you die at some point down the road. Okay, so now let's look at the value at death. So let's say the bank account just had, there were some deposits, there were some withdrawals, went back and forth, but in the end, let's assume there was no real change to it. It ended up with 100,000. So your intent to give your son an equal amount, maintain the same. Now let's look at the joint real estate with the daughter. Started out at 100,000, but what if the home was sold? What if there's a mortgage on the property, or any other reason that could be out there that ownership would have changed, or that value would have changed? So you could really end up with the range from all the way from 0, or if the home appreciated greatly, to higher than 100,000. So you can either take the daughter and reduce the initial $100,000 gift, or it could expand. But again, if you sold the home, that's an issue, because now what does the daughter have? Nothing. If there's a mortgage on the property, what does the daughter have to do? Pay the mortgage off. So that 100,000 could be reduced all the way down to 0, depending on the fluctuations in real estate. Moreover, remember that home is also subject to the daughter's creditors during her life, because it is an asset. She is on title to it. And there's also potentially gift tax consequences. As we see here, there's $100,000 in equity given to the daughter. That's a gift to the daughter during your life. So now you have to file a gift tax return with the IRS. Okay. Now let's go to the third asset. Again, started at 100,000, but at the value of death, it is increased over time, as most IRA investment accounts. If you take no withdrawals, or only just the minimal required minimum distributions, and you get a great investment, or even a standard investment, is going to increase. So now let's look at this from in that right-handed column, the value at death. You have $100,000 for the son, potentially 0 for the daughter, and $250,000 for the new spouse. So the question was, we started at equalization. Now we're very far from that. So out of the $350,000 worth of assets here, we got a $250,000 going to one individual, new spouse, and $100,000 going to the son, and the daughter with nothing. That's how they fail. They don't equalize over time. So what may seem equal at the time of the estate planning is not necessarily going to be equal at the time of death. Wills are a step in the right direction. They're better than the do-nothing default and test it, because in a will you can direct what you want to do. They are easy to set up in the beginning, because really all the work happens after you die. Just document, you sign it, get some witnesses, and there you go. Not too difficult to set up. After you die, someone has to read it and interpret it and make sure what it says happens. There's no need to fund it like you do with the trust, because all this happens through probate after your death, which is also a really big negative. The cons are it has no incapacity protection, because again, it only functions after you die. You must go through probate. Probate is a public and potentially expensive process. The way probate works is you file a petition to probate, pay the filing fee, $400+. You're going to have to likely get a bond, unless the will says not to have a bond, but you may have to get a bond, additional fees. You're going to have to publish notice in the newspaper to creditors, additional fees. You're going to have to notice all the potential heirs out there, again, additional fees. Then you're going to have to hire a probate referee to value the estate, again, additional fees. So as you're paying all these fees, not only that, it's public, it's court, it's a public record. That's how you can tell, you've seen the headlines where it's like, this star's estate was this, or this famous person's estate was that. And that's because it's a very public process. So when you're going through these notice requirements to heirs, that allows an heir to come in and dispute, and can create conflict. And sometimes they'll do that just not because they think they have a really strong case, but they'll do it because they know that it's easier to settle than pay attorney's fees. Not only that, probate is expensive. Attorneys get paid out of that. We get a statutory fee, which is quite significant overall. It's just based on a percentage of the gross value. So if you have a residence that is $500,000, even if it has a $400,000 mortgage on it, the attorney's fees are based on a percentage of that $500,000, not the $100,000 in equity. So it could all get eaten up relatively quickly. The personal representative could also be paid from the estate. So what could ultimately trickle down to the heirs could be very minimal. So it's a step in the right direction, but it's not quite the end result. Trusts are great. They really are the all-in-one tool. There's pros and there's cons, and the pros far outweigh the cons. When you think about what a trust is, it's really, at its essence, a contract with yourself. Okay? You're agreeing to transfer property to a trust that you control during your life and can revoke it, quite frankly, during your life, as long as it's not an irrevocable trust. And the only reason you do irrevocable trust, well, not the only, but one of the main reasons is asset protection, or if there's some reason you don't want it included in your estate for tax purposes, you can deal with it through an irrevocable trust. And there's other reasons why, but in a revocable trust, you can tear it up during your life, you can modify it, you can amend it, a lot you can do with it. It also has robust incapacity protection. A revocable trust provides for an incapacity trustee. So if you become incapacitated, anything owned by the trust is governed by the trust. There's no need to go to a probate court and have an individual appointed to make decisions for you. Okay, so it has robust incapacity protection, and you can direct what they can and cannot do. It's also private. There's no probate court. It's less costly settlement or administration after death compared to a will, which I just said. Remember all the fees, the filing fees, the publication fees, the notice fees, the probate referee fees. There's a lot of fees that go into a probate proceeding that you can avoid through using a trust. And unlike a will, it can be joint, making it easier to manage during your life. So you and your new spouse, it can be joint. So your new spouse can be taken care of while protecting, the children from the prior relationship. And that's why it helps to promote family harmony and unity. You set it up so everyone knows what's going to happen. There's no fighting because it's you who directs what's going to happen during your life and then when you pass. There are also many types of trusts. So there's nearly always one that will work for your family and your goals, okay? The cons are it does require you to fully fund it during your life to achieve the best benefits. And what that means, if you have a resident, you transfer the resident into the trust. But remember, you're the trustee. Now you and probably your new spouse are the trustee during your life, so you both can control it. But once one of you passes, that's when it becomes irrevocable and has some robust protections for the children from the blended family scenario. It's a little more work in the beginning to set up. It's definitely more wordy. Your typical revocable trust will be 30 plus pages, whereas your typical will is somewhere to 7 to 10 pages. Okay, so in the beginning you have to do it. Plus there's the transferring the assets into the trust. So when we go back to that payable on death, transfer on death, we talked about creating a bank account. Say mom is getting old and needs to be taken care of. She has her bank account. She adds a child. You don't do that anymore. Now you just create a bank account in the name of the trust. And so therefore, it's a little more work in the beginning, but that protects the daughter's creditors or the child who's taking care of mom's creditors from attaching the bank account. It also guarantees that the money would not just be taken by that child, and your trust then would dictate how it would happen. So it's a little more work, but it's much easier for your family. The other part of probate that we didn't really talk about is just how long it takes to get through a probate proceeding. It is a significant period of time. When you use a trust, it just keeps ticking. You don't have to wait. There's no notice provisions. You don't have this 120-day window where you have to sit there and wait for creditors to file claims. You literally just keep ticking. There's no delay. Your trustee takes over, follows the direction of the trust. That's what makes the trust great. So let's talk about the all-in-one tool. Say typical, you have investment, heirlooms and personal property, bank accounts, home and real estate, and other property. These could all be probated, but no, we'll put them in a trust, right? You use a revocable trust assets as you always have while you're alive. Again, you're in control. It's revocable. You have beneficiaries or surviving children, spouse and other children. You put them in there so they're all on the same page. There's no probate fees. They do have some settlement costs, but they're typically much lower, as I described, plus more timely. Taxes, depending on your acts mix and level, some taxes may be due, but your plan will eliminate as many taxes. You have that flexibility to determine what's the best kind of trust, how the assets should be handled, instead of going through a probate court and having the probate judge deal with it. That's why trusts really are the all-in-one tool. All right. In a blended family context, the key there is you may have competing interests when you pass. And that interest could be new spouse and prior children. Now, you don't want new spouse to be able to cut off prior children if that's your intent. Okay? You also don't want new spouse and your children from a prior relationship to suddenly be litigating, and everything you've worked hard for is now just being spent on attorneys. And not only that, what that really does to a family is it really just kind of tears it apart in many ways. Children and new spouse fighting over something. The worst case I saw was where new spouse told the family, the children from the previous spouse, that there was a trust in place, but there really wasn't. So when dad passed, children always believed there was a trust in place, and the trust put new spouse or stepmom in charge, and then when stepmom passed, it would trickle down to these children as well as the joint children from dad and stepmom. Well, as it turns out, there was no trust in place. Stepmom got to sit there for 10, I think it was actually 11 years before it was realized that there was no trust. So she got to enjoy everything for that period of time. It ended up in litigation. Lots of money was spent on both sides to litigate out this estate. A settlement was finally reached, but it took years and it took a lot of money. And not only that, what it really did is children from a prior marriage who got along with their step-siblings no longer got along with their step-siblings because the step-siblings sided with their mom against the children from the prior marriage. That's the difficulty, is that it really can tear a family apart. So where there was once family unity, or a version of it, where there was once this version of family unity, 13 years after he had passed, we're sitting in mediation to settle this, and both sides are just very upset. So in a blended family, you really have to be cautious. You really have to put a plan in place, because the do-nothing approach does not work. The joint tenancy, or the transfer on death or payable on death, creates issues as well. And a will just puts you in probate. So what I'd like you to do is, my website is www.gillalandlaw.com. There's 3 L's in there, G-I-L-L-I-L, and another L for law, but the name has 3 L's. On my website, there's a contact form, contact us form. You can fill that out. We will then contact you and set up a free 30-minute initial consultation. What we'll do there, sit down, meet, see if you like me, see if I like you, and we'll go from there. Typically, after I understand a family situation, I can give you a flat fee price on what we're going to accomplish, at least for the portion of creating the plan. And then when we get to the funding, the putting the property in the plan, we can talk about that as well. So what we really want to do is get a holistic approach to your unique family situation. That's the goal. That's why I take what I do very seriously, and I love what I do. If you do mention this webinar, I'll give you a little kicker. We'll take $200 off your estate plan. And to be clear, that doesn't mean I'm going to increase the price of every estate plan $200 and go, oh, now you got a $200 off your estate plan. My fees are set. I know what range that most estate plans happen, and I'll tell you that. I'll be very upfront with that. So again, contact me at gillalandlaw.com, and then we'll reach back to you, or you can send me an email at my name, andrew@gillilandlaw.com, or even call me, 951-296-0205. So, questions. And one question I've been asked a lot over the years is, well, I have a power of attorney, does that work when mom or dad dies or spouse dies or child dies? And the answer is no. Power of attorney is only good while the individual is alive. So that does not work. That's a very common question. Another common question is, so what happens when I die when no plan is in place? Again, you end up in probate. You end up in an intestate proceeding. The court will appoint somebody to handle the estate, get a bond, and then answer to the other heirs. As we spoke out, that's a lot of time and a lot of money that goes out the door. All right, another question is, what is a living will? This is the document that provides your healthcare providers, information regarding your wishes should you not be able to convey them. So basically, in an estate plan, you appoint somebody as your medical agent who makes decisions on your behalf, and then the living will tells them, in a worst case scenario, with do you resuscitate or not, or whatever other wishes you have, you let them know what you want. So those two work hand in hand. All right. So the bottom line is this: you don't want to leave your family a mess to clean up. That could destroy your family relationships. You want to take charge of your legacy and begin the planning process. That's what doing an estate plan is about. Take charge of it. Take care of it. Don't leave your heirs with a problem. Thank you, and I look forward to hearing from you.